Good day. My name is Chioma Ngige, an associate of OALP in the dispute resolution practice. And today we are commencing our dispute series. We have the privilege to be joined by one of our partners of our dispute resolution practice, Dr. Echefu Ukattah. You're welcome, sir.
Pleasure is mine, thanks.
And today we're going to talk about the trend in the maritime sector in Nigeria, particularly in light of the recent Supreme Court judgment of General Hydrocarbon and First Bank. Let's start, sir. In your line of experience, in your years of experience, we have often seen when lawyers or even clients themselves mistakenly, or would I say intentionally, couch their normal commercial claims as though they were maritime claims. And thankfully, the Supreme Court in General Hydrocarbon and First Bank has clarified this confusion. So what are your thoughts on this?
Thank you, Choma. I think this issue is a perennial issue that we have in our maritime practice in Nigeria, and this is really not the first time such a case is coming up before our appellate courts. It came up in the case of the MT Gaia, and now we have the hydrocarbon, General Hydrocarbon, and the First Bank case. The thing is, we often see litigants, and also not just litigants, also because litigants come to lawyers, and lawyers in attempt to achieve the commercial objective of litigants, which most times is to obtain a form of advantage in the form of an arrest of a vessel, and then to be able to get security with respect to that arrest of the vessel. You see them couch purely commercial disputes that are not maritime claims as seeing their maritime claims. So in this recent case of the Supreme Court, even though the judgment has not been published, what we see in the public domain with respect to the decision of His Lordship, Honorable Justice Agim made it very clear that even where your pleadings or even the release that you're seeking, you make it seem as if they're in relation to either a vessel or cargo on board a vessel. The mere fact that a vessel is involved or property on board the vessel is involved does not really make it a maritime claim. For a claim in Nigeria to be a maritime claim, you and I know, Chairman, that it has to either be a proprietary maritime claim under Section 2 sub 2 of our Admiralty Jurisdiction Act, or it is a general maritime claim under Section 2 sub 3 of the AJA. And basically, Section 2 sub 2 of the AJA is about claims with respect to ownership, position of a vessel, or security over a vessel, a share in the vessel, or security over a freight of a vessel. And then the general maritime claims, in a nutshell, are claims with respect to arising from the use or operations of a vessel or services rendered for the use and operation of a vessel. So in a nutshell, if your claim does not fall under either Section 2 sub 2 or Section 2 sub 3 of the AJA, it's not admiralty matter. And if it's not admiralty matter, really, you cannot go to court, commence an action in rem, and obtain an order of arrest of a vessel with respect to such claim. Such purely commercial disputes, depending on the court that has jurisdiction, should be treated as purely commercial dispute, not admiralty claims. I have mentioned the MT Gaia case. The MT Gaia case was a case where somebody appointed an agent and wanted the agent to assist in the purchase of a vessel. The agent breached the fiduciary duty that he had towards the appointer, and then the appointer then went to court, then went and sought an order of arrest of the vessel that was there at the end of the day. When the matter got to the Court of Appeal, the Court of Appeal made it clear that even though by the release, because the way they couch the release, that's what normally happens. They'll couch the release as if it's a relief in respect to an admiralty matter. So the relief in that claim was for title and possession with respect to the vessel that was involved. But the Court of Appeal said that you can't just look at the reliefs of a party. You have to construe the release of the party together with the pleadings. And the Court of Appeal said that by the pleadings, that it was just a purely commercial dispute, it was a breach of fiduciary duty and not an admiralty matter. But like I said to you, Chioma, it's always about parties trying to, because you're just trying to find a way to, be able to um, make the defendant to come to the table. And the easiest way of doing this is if there's a vessel involved, you arrest the vessel, and then you are now looking for security to be given to you for the release of the vessel. So before judgment, before even trial, you have a form of prejudgment security.
And that brings me to my next question. So, for the purpose of the viewers and listeners that have no idea on how to protect their vessel from this arrest, what steps can they take, and what would you say has been the attitude of the courts concerning this?
Well, the most pragmatic step beyond your risk assessment and when you enter into contracts with people and contract management, trying to make sure that these things don't arise, I always tell ship owners, and when I'm talking about ship owners, interestingly, some rig owners in Nigeria don't even know that rigs under our AJA is a ship. So I've had instances where I've had to even recently to tell rig owners, look, you have a ship. And they were like, no, it's not a ship, it's a rigger. So under the AJA, it is a ship. So the easiest way and the most pragmatic way of protecting your ship as a ship owner in Nigeria is to file a caveat against a rescue vessel. So the way it works is the caveat, the form is at the schedule of the AJA.
Yeah.
The way it works is that your agent or you as a ship owner or your agent or even a third party that has interest in a vessel will file that caveat in court. So in the caveat, typical language you have in the caveat is that we, the agent of this ship owner, we are filing this caveat in relation to, you mentioned the name of the vessel and the details, the IMO number of the vessel. And then state a value that if anybody has a claim as against this vessel up to these amounts, so you state the value might be up to 50 million naira, that side your claim on us, and they will provide security with respect to your claim. But interestingly, what we have seen in the years of our practice is that, and this becomes apparent most times after the arrest of the vessel has been done, and then you are now served the claim of the party. What we have seen is that sometimes people take steps to circumvent the effect of the caveat, because what the caveat does is that based on our rules, once there's a caveat in place and the value of your claim is less than or up to the value in the caveat, you cannot arrest. Even if you apply to arrest the vessel, the court shouldn't give you the order of arrest. So what they normally do is when they go and conduct a search at the caveat register, for example, and then they want to arrest the vessel that belongs to our clients, they conduct a search, and then they see that there's a caveat in place. The next thing they would do is to check the value of the caveat, the value stated in the caveat. And then if, for example, they see that the value stated in the caveat is 30 million naira, and the claim they have ordinarily, which most times is in the special damages, most times the monetary claim, special damages, and their claim is 20 million. Mind you, the value stated in the caveat is 30 million naira. And then the value of their claim ordinarily is 20 million naira. When they see that, after conducting the search, they go back. So what you now typically see in claims when the claims are then served and after they've obtained an order of arrest is that they then go back and then have in the relief section special damages 20 million naira. And then they now have general damages 100 million naira. So the aggregate of the general damages and special damages will now make their claim to be above the value stated in the caveat. And then they can then go to court. On the basis of that, they will now go to court and say, my lord, we conducted research. Yes, there's a caveat against arrest in place with respect to this vessel. However, the aggregate of the value of our claim is above the value of the vessel. But it should not be so. It is in a crime that you see such practices, but that was never the intention of having a caveat in place. And another thing that we saw before now, because I was privileged to be a member of the subcommittee that was set up by the Nigerian Maritime Law Association to review the admiralty rules of 2011. Now, what used to occur in court, and one of the days I was in court, a judge raised this issue. They'll go to the caveat registry, and to go to the registry of the court, and then they conduct a search in the cabinet register. And please, I need to point out something. Now, the 2011 rules does not use the word conduct a search. The 2011 rules, that 7 says procure a search of the caveat register. Procure means more than conducting a search. It means you obtain something. But there was nothing in the 2011 rules that said that you have to be given something, but the Admiralty Marshal, to show the outcome of the search that you conducted on the caveat register. So people would typically come to court in the affidavit in support of the application for the arrest of a vessel. They will then have an averment that they applied to search the caveat register. They will attach the application as proof of the application. And then they would then say, we were informed by the Admiralty Marshal that there was no caveat, against arrest of the vessel filed with respect to this vessel. That blunt assertion. Nothing that you didn't, they don't procure anything from the Admiralty Marshal to show the outcome of the search. I remember one of the days, Justice Professor Biozo was telling somebody, you can't just come before me and then you just make a blunt assertion that I was told by Admiralty Marshal that there's no caveat against it. Where is the outcome of the search that you conduct? So what we then now did now in the 2023 rules is now have it that now after procuring the search of the caveat register, the Admiralty Marshal is now to give you a report. So that really go a long way in making the judge to, know truly if what the outcome of the search of the caveat register was. So the issue of circumventing caveat is, one of the things that we have seen in our practice in the maritime sector. And then this also dovetails into the issue that I also think is pertinent that we talk about. The value of the security people ask for when they come to arrest a vessel in Nigeria. And I will try in a nutshell to explain why it's a problem. Now, typical applications that you see with respect to arrest of the vessel is the plaintiff will go to court and file an admiralty claim, an actual in rem, and then accompany with an ex parte application. And the other party is not going to be served. Ex parte application, and the ex parte application, they will now be asking for an order of arrest of the vessel with respect to their claim. And then they would then, second prayer they will be asking for is that the court to make an order that that vessel will only be arrested, will only be released from arrest where the defendant provides, usually the owners of the, so they might sue the vessel and the owners. So where the owners of the vessel provide security from a tier 1 commercial bank in Nigeria as to the value of their claim. That's what they will ask for. And typically the courts will make such orders. And I'll explain why that is a problem, because it's not in tandem with our law on this. Now, the issue of security for the release of a vessel under arrest, from the conception of that principle of law, it was never meant, strictly speaking, for a plaintiff to get prejudgment security as to the value of his claim. It was never meant to cover the value of the claim of a party. It was meant to serve as a substitute for an arrested vessel. So typically what you're saying is, this vessel of mine, if I'm a ship owner, this vessel of mine that you have arrested, release it to me and I will give you something to take her place. So that's why that security is called substitute security. Some jurisdictions call it alternative or alternate security. It's taking the place of the vessel. So in essence, it is not for you to get the full value, security as to the full value of your claim. In certain instances, it's possible for you to get security as to the value of a claim. And that is why in admiralty law, we have this if you go to Admiralty Rules of 1993, we have it there. The 2011 rules, it was there. 2023 rules, it's there. Yeah. And also, even before the rules, Admiralty rules in Nigeria, as far back as 1956, there was a case of the Anchor Limited and the owners of the ship Eleni. It was a case that was decided, and the person that gave that judgment, certain FCJ, it was actually the first Chief Justice of Nigeria. Most people are not aware of this. It was a white guy, but it was the first Chief Justice of Nigeria. Sutton laid down the principle, and which is the principle that came from English admiralty law, even though at a point there was a deviation in the case of the Muscanti. But I don't want to talk about the Muscanti now. I've written things about the Muscanti, but let's be on track with respect to. So this was the principle in our law as far as 1956 of our Supreme Court. And they didn't have that principle in the 1993 rules, 2011 rules, and 2023 rules. They made it clear in the rules, and in that case, that the value of security that you are to be given as an arrest of a vessel for the vessel to be released from arrest is value as to security as to the value of your claim, or as to the value of the vessel, whichever is less. So to illustrate it, what it means is that whichever is less principle, what it means is that if the value of your claim is 20 million naira, and then the value of the vessel you arrested is 50 million naira, what you are to be given security for is as to the value of the claim, which is 20 million naira, because it is less than the value of the vessel. So in this instance, even though the essence of security is not really to cover the value of your claim, in this instance, you proclaim security that covers the value of your claim, because the value of your claim is less than the value of the vessel.
Okay.
But let's reverse it. Now, the value of your claim is 50 million naira, and the value of the vessel that you arrested is 20 million naira. What you are to get, based on the principle of whichever is less, is the value of the vessel, 20 million, because it's less than the value of the claim, which is 50 million naira, whichever is less. So in this instance now, you are not getting security as to the value of your claim. So we then go to court, and we're then asking the court to order that for the vessel to be released from arrest, it has the same value of security has to be as the value of your claim, plus interest and cost on the basis of your best agreeable case, which is the principle in the Muscanti, which the people in our jurisprudence were citing the Muscanti for our courts, even though our admiralty rules provided otherwise. So we had a case that came up, some years back in Uyo, in Akwa Ibom State, where a party went and asked for a value of security as to a claim of over $500 million. Which bank in Nigeria then could give us a bank guarantee as to that amount? So for the first time in the history of maritime practice in Nigeria, we went to court, applied to the court to vary that order to read the value of the claim or the value of the vessel, whichever it is. After all the arguments and the other party citing the cases of the Court of Appeal and the Federal High Court that follow the Muscanti rule, and all citing the rules of court and saying, look, the rules of court provide for this. And if the rules provide for this, that's what the court should apply. And the courts agree with us. And then I apply that principle. And the second thing is you going to court and then asking the court that it must be a bank guarantee is also another issue that I have. Because the admiralty rules provide that it can be a bank guarantee or a PNI club letter or an insurance bond. So if I were a judge and you come before me and you want to narrow it down to a bank guarantee, I will not do so. I will provide those options, because you might not be able to get a bank guarantee from a bank as a ship owner. You can get an insurance bond, or you can get a PNI club letter. So I think also, in our jurisprudence, in the maritime practice, people going to court trying to restrict the form of security to be obtained instead of leaving out that window. They will say it's pragmatic. Yes, really, it might be, but really, a judge should be able to give the other options, even when you ask for only bank guarantee. And a judge should know and understand, and even you as the arrestor, that security, the value was never for you to get full value of your claim, but for you to get a substitute for the vessel that's under arrest. So in certain circumstances, that substitute might be enough to cover the value of your claim. In certain circumstances, it might not be enough to cover the value of your claim.
So what do we now say about people that have their vessels wrongfully arrested? How are they protected by the law? And with your experience, what have you noticed? What are the trends?
Yeah. So Chioma, is a very interesting issue, and it's an issue that is very, very dear to my heart. I've been, privileged to apply on behalf of ship owners and claim damages for wrongful arrest of a vessel. And in one of the cases, Honorable Justice Faji awarded 10 million naira in favor of a client for wrongful arrest. But I have an issue with the current admiralty rules of 2023, and I will explain. Well, if you go back in time, as from 1993 rules, you check or the NIRI, one of the 1993 rules, and then 2011 rules, you check the 2011 rules, you will see that, and then the AJA too, you look at the AJA, with respect to section 13 of the AJA, what our law was, and I'll explain why it became so. What our law was, or still is, I will say is because the AJA still has it. It's just that, we no longer use 1993 rules and 2011, we don't use 2023 rules. 2023 rules is not pragmatic, and I'll explain why. Now, the AJA provides that the courts, you are entitled to damages for wrongful arrest of a vessel where the vessel is unreasonably and without good cause arrested.
Yes.
That's the principle in the AJA. This is the same principle in the 1993 rules. It's the same principle in the 2011 rules. Prior to that, prior to the AJA and 1993 rules and 2011 rules, the principle then was that it wasn't enough to prove the vessel was wrongfully arrested. You had to prove that the person in doing so acted in bad faith, or there was gross negligence on the person's part, crassa negligentia, or that it was done unlawfully. Now, there's this case, the Bosnia too, where the owner of the vessel, after the vessel was arrested, applied for the release of the vessel from arrest, and the courts agreed and that the vessel was wrongfully arrested. But however, the Emeka rule, JCA, as it then was, now did not grant damages for wrongful arrest of the vessel. And the reason he didn't grant was that he said, look, it is not enough to prove that the vessel was wrongfully arrested, because you have to now go beyond that to prove either bad faith or gross negligence.
Yes.
And that these are issues of facts
really
that you have to lead cogent evidence.
Yeah.
And that the threshold is not
easy.
It's not easy.
Yeah, very high.
It's a high threshold.
Yes.
And so in that case, there was no evidence to show bad faith or gross negligence.
Yeah.
So under our law now, we then made an informed decision to change it, because what it means was free for all. People were just arresting vessels.
Yes.
And then when the ship owners now come, even though the courts hold that the vessels were wrongfully arrested, but however, because there was a high threshold, they couldn't prove bad faith or gross negligence. We made a decision under our law to then have the principle of unreasonably or without good cause in the AJA 1991. And then AJPR 1993, we have it there. In the AJPR 2011, we have it there. We then came down in the 2023 rules to then go back to the same principle of bad faith or gross negligence. So, in essence, what we have now done is to say, look, we're jettisoning all these good principles of law that we have in the AJA 1991, AJPR 1911, AJPR 2011, and going back to bad faith. So people now in Nigeria now can go and arrest your vessel wrongfully, and then you as the ship owner might not be able to get damages for wrongful arrest of the vessel because you'll be unable to prove bad faith or gross negligence. So I think you're looking at the state of our law with respect to that. I think it's something that we need to change, but I don't think that would really have an impact at the moment. And the reason I say this is this, that when the AJPR was being amended to have the AJPR 2023, the intention was also to amend the AJA so as there will be consistency with the provisions of the AJA and the AJPR. In the AJPR, the CJ of the Federal High Court issued the AJPR, but for the Act of National Assembly, there's a process for amending the Act. So the AJA is yet to be amended. So currently in the AJA, what you have is still unreasonably and without good cause. AJPR now says bad faith, gross negligence, and that AJPR being subsidiary legislation cannot expand the Act. It can only expound an Act. So a court of law, if a case comes before our application comes before you for wrongful arrest, damages for wrongful arrest will still be bound to apply the definition of the AJA unreasonably and without good cause. So practically, this is in a nutshell, is really some of the things that we've seen in the market. In subsequent series on this, we'll talk about some of the other issues that we have faced in the market and we have in practice, the maritime practice in Nigeria, and we keep seeing. And we also intend to call the veteran in the industry to come and talk to us, because there's wisdom in hearing from people who have gone ahead of you, people who saw the maritime market in Nigeria develop up to the stage where it is, to talk to us about developments in the market, for us to have a broader picture of the maritime industry and maritime practice in Nigeria.
Thank you so much, Dr. Echefu. Such a nice way to commence our series. And to our guests, thank you so much for tuning in today's episode. Until next time, thank you.